Welcome back to our second lecture in which we're going to discuss the topic of employment at will. We covered much of this during earlier presentations, so I'm going to do a pretty quick review of this. As I said in the earlier lecture, employment at will is the default rule in the United States. It is the main way that we look at employment relationships. And the bottom line is that either party may terminate the relationship at any time for any reason unless that reason is prohibited by law. You probably already have a definition of at-will employment in your notes, but if you don't, this is a good one to use. As I said before, this is reciprocal. The employee has this right and the employer has this right. We kind of assume that the employee is going to have this right, but the fact that the employer can dismiss his or her employees at any time, with or without notice, with or without cause, unless there is an unlawful reason in play, sometimes surprises people. Keep in mind that the at-will employment doctrine applies only when there isn't a formal employment contract. So that's how employment at will works. I've posted this case, Montgomery County Hospital District v. Brown, that goes over the Texas rule about employment at will. Here's an excerpt from the case. For over a century, the general rule in this state, as in most American jurisdictions, has been that absent a specific agreement to the contrary, employment may be terminated by the employer or the employee at will for good cause, no cause, or bad cause, or no cause at all. So that's a nice summary about the rule in Texas and pretty much everywhere else. The only jurisdiction that arguably is in employment at will is the state of Montana. And really, I would argue that while they've abandoned that terminology, the actual rule that is in place is pretty darn similar to what we have in the other 49 states. So one way to think about employment at will as an employment contract that renews itself every second of the employment relationship. And if it doesn't renew at 12:57 p.m. on a particular day, then it goes poof. But if both parties, the employer and the employee, want to continue it, then it'll continue to 12:58 p.m. and then it'll continue to 12:59 p.m. and so forth. But at any minute, either the employee or the employer is free to say, well, I'm done, and it ends at that second. It is not renewed for another minute. Now, I said that employment at will is the usual rule, but there are some important exceptions. Government employment can be different than employment at will. Not all government employees are, some of them are employed at will, but after they have a certain length of tenure, there is some constitutional implications. People are said to have a property interest in their job at that point. That only applies to government employment, not in the private sector. We also have the fact that when an employee is part of a organized union group that has an employment contract with an employer, under those circumstances, the collective bargaining agreement controls. Now, it's possible for a collective bargaining agreement to have an employment at will component, but that's unusual. Most of the time, they have a for-cause employment standard. And then, of course, we can have just traditional individual contracts of employment. But the vast majority of private sector employment is going to be at will. I would argue that it's well over 90%, probably over 95%. So we're going to talk about the exceptions to employment at will. But again, it's really easy to start thinking, because when we talk about these exceptions, and there's a lot of them, but they make up a very small percentage of all the terminations. But it's easy to start kind of thinking, oh, well, most of terminations fit into this exception category. No, the vast majority of situations, the employment at will doctrine applies. The employee can leave at any time. The employer can end the relationship at any time. But I have 5 categories that we're going to talk about in this and subsequent lectures. The first is about violation of an employment law statute. pretty much the rest of this class, or at least 60–70% of this class, is about this topic. It could be race discrimination, sex discrimination, a Family Medical Leave Act issue, a WARN Act issue. I mean, there are so many different statutes. I'm not going to go into the nuts and bolts of this because, again, it would take hours to do it. That would be the whole course. So I'm going to go immediately down to our second item, which is because of a public policy or similar issue. So let me go to the next slide. So an exception to the at-will employment doctrine is bad faith or malicious termination that may violate a public policy right. And other terms for this that you'll oftentimes see is wrongful termination, someone being a whistleblower, sometimes it's described as a tort claim or retaliation claim. The rest of this lecture, we're going to focus on this bullet, and then in other lectures, we'll finish up these lists. So let's get started. So again, this is just one bullet, but it's actually a really big category. So we're going to be spending quite a bit of time figuring that out. And we're going to be a little bit more granular. We're going to divide up this bad faith or malicious termination of employment to 4 categories. The first is that public policy issue. Another is going to be whistleblower claims. And we have torts and retaliation claims. So let's get started on this topic. So wrongful termination, you can see this term is in red, so you want to add it to your Quizlet. And again, this is a good definition that you may want to consider. I've defined the term wrongful termination, but I almost wish I hadn't, because it's really not a term that legal professionals like to use, because it's very vague. And in fact, the average person on the street uses this expression, but they almost always misuse it. And so it really doesn't mean what people think it means. What people tend to think it means is that an employer can't dismiss you unless it has a good reason. In other words, they see this as the standard instead of at-will employment. Not at all the case. An employer can fire you for a bad reason, can fire you for no reason at all. The only thing an employer can't do is fire you for an illegal reason. And so not liking you, not liking the shirt you're wearing today, not liking the fact you were 5 minutes late, all those things may be stupid reasons to fire you, may be unwise reasons to fire you, may be mean reasons to fire you, but they're probably not unlawful reasons to fire you. So you have to keep in mind that there has to be a law that is involved that would make the termination wrongful. Not just that it's unfair, not just that it doesn't seem right. So again, we're going to tend to avoid this term. People oftentimes use the term wrongful. People who are using it correctly use the term to refer to any kind of non-statutory reason, more in the common law type category. So if we go back here, people would oftentimes call these reasons wrongful termination reasons. Maybe not this one, because this one tends to be more statutory, but the first 3 might be a wrongful termination situation. But again, it's better to just be more specific. Now, there is a trend in the United States to, I guess, a public opinion type thing, is that there's more and more inclination of the public to see to want to limit employers in terms of the reasons that they can dismiss people. That is definitely a trend, and we've seen that pretty significantly happening in states like California, Wisconsin, New York State, where we see that statutory, in some cases judge-made changes have restricted the ability of the employer to apply the employment at will doctrine. Those doctrines still exist in those states, but they have been, the exceptions have become much more significant. We haven't seen that trend in Texas yet, but certainly it is possible that in the future we will see this happen here as well. So it's always a good idea to stay abreast of the law in this area so that you know where the public opinion is and where our legislature is on these issues, because we definitely could see some shifts in this area. and the wrongful termination category can become more significant. Right now, it's not very significant in Texas. Let's examine the word public policy. This word is important in lots of different practice areas. Amidst the idea that certain things injure the public and they're against the interest of the public to permit. I'll give you an example. Let's say I've got 2 healthy kidneys. I'm a little short on money. I'd like to sell one of my kidneys to somebody who's wealthy, who needs a kidney. The person has enough money. It's kind of a good deal. He gets the kidney he needs. I get the money I need, and I still have a healthy kidney, so I probably will be just fine. You could argue that that's just a business transaction, kind of like me selling my labor to someone, and they're getting the benefit of that labor. Another example would be prostitution. The idea that I can prostitute myself and sell my services in that area, and I'm getting money. The person who I am prostituting myself with gets that experience out of, and so you could say that that is a win-win for the people. At least they think it's a win-win. But no, we have concluded as a society that those types of arrangements are injurious to the public. They're against the dignity of the human experience. We shouldn't be reduced to body parts. We shouldn't be, our sexuality shouldn't be monetized, those types of ideas. You could imagine that different public policies at different times could be important. One of the public policies, we had the idea that children shouldn't work. We don't allow children under the age of 16 to do very many jobs. But you could imagine that a 14-year-old or 13-year-old might be very good at doing certain tasks and might enjoy the income. And yet we say as a public policy, no. And yet the public policy is, the protection of children. And so those are just examples of how public policy can play a role here. In many states, there are public policy doctrines that limit what an employer can do with an employee who's engaging, say, in whistleblowing activity. Usually when you see discussion about public policy issues, it's because there is no relevant statute. I mean, if you have a statute, the public policy has been expressed in the legislation. Obviously, the legislature is the entity that kind of has its hand on the pulse of the body politic. And so it's the expert to know what the public feelings are on this particular issue. So when you see courts opine about public policy, in the vast majority of cases, they're talking about something that they've identified as a public policy that the legislature has not yet grabbed a hold of. An example of that, this is going to date me, but when I was in law school in the late 1980s, there was a pretty big case that popped up. It was called the Baby M case. In that case, a man and a woman hired another woman to become pregnant through artificial insemination. And the idea was once she gave birth, she would surrender her custody of the child to the husband and wife, and the husband and wife would become the lawful parents. The husband was the biological parent. The wife would become the adopted parent of the child. What happened was the surrogate, who was also the biological mother of the child, changed her mind and wanted to retain at least partial custody of the child. And this was quite a story in the culture at that time. And the case arose in the state of New Jersey. Well, at that time, the idea of people doing this hadn't really occurred to the legislatures, at least not the legislature in New Jersey. And so there was no statute that prohibited this type of behavior. It was unlawful to sell children, but in this case, the husband was in fact the biological father of this child. So you can't buy your own child. And so it didn't really fit into the child selling category. And so as a result, the judge was forced to make a decision about it. And so he, of course, looked very closely at the public policy components. Obviously, if he had had a statute that he could look at and see what the legislature had decided in this situation, that judge's job would have been a lot easier, but it just didn't exist yet. So you'll see many times when you hear talk about public policy, you'll see that there probably isn't a statute in play. So what is the Texas public policy protection for employees? It's extremely meager. There is just one case out there, and it is extremely limited to its facts. Other litigants have attempted to broaden Sabine pilots, that's what people call this case, but haven't been successful. So the public policy argument really isn't a winning argument in Texas. Other states, it might be a winning argument. What happened in this case is Mr. Hawk was dismissed from his employer, Sabine Pilots, and he claimed that he was fired, and the only reason he was fired was that he refused to perform an illegal act. It had to do with bilges and releasing, I think it might have been oil, and maybe it was in the Gulf of Mexico or maybe the Port of Houston, I can't remember exactly where, but it was a crime to do what his boss wanted him to do. He refused to do it. He was fired for that reason. And the Texas Supreme Court says, no, you can't fire your employee because the employee refuses to commit an illegal act. But this is a very limited decision. First of all, it has to be the sole reason. So let's say he had had an attendance problem as well, and the boss had said, well, I'm going to fire you primarily because you refuse to commit an illegal act, but also because you're not that good of an employee. You tend to be late to work. Well, then we wouldn't have a sole reason situation, and Sabine Pilots would be free to fire Mr. Hawk, even though his refusal to perform an illegal act was an important part of the reason. Also, there is no public policy exception for an employee who merely wants to report somebody else doing an illegal act. So let's say Hawk wasn't asked to do the act, but someone else was asked to do the act, and Hawk either threatened to report that individual or his employer to the proper officials or actually did so. That isn't a public policy exception. It would be lawful for Sabine Pilots to do that to Hawk, to dismiss him. So it's a very, very limited holding. I've posted the case on Canvas. You are responsible for being familiar with it. You don't need to know any more about the facts than what I've just shared with you, but it is an important case in the state of Texas. And again, it's important in many senses, not so much because of what it says, but because of how limited the exception is. In other states, you'll see that public policy protections can be quite a bit more extensive. Now we're going to talk about whistleblower claims. We've all heard the term whistleblower, the idea that somebody is blowing a whistle or alerting the authorities to the fact that there's some type of unlawful action going on. We're going to talk primarily about whistleblowing in this section related to government employment. And the reason that I'm limiting it to that topic is that when we get into other sections, we'll talk in more detail about the private sector. Whistleblower protections, as we talked about with the Sabine Pilot case, don't automatically attach in private sector positions. You don't have those. Sometimes you can point to a statute that gives you protection, but in Texas, at least, you're not going to have any common law protections. Otherwise, we would see protections in Sabine Pilot. But in the position of state and federal employment, many times those employees do enjoy a certain level of protection. Again, we have a term here, a whistleblower term, and we have a definition. So you want to be sure to flag this definition. So what does an employee who is dismissed and who wants to assert a whistleblower claim need to prove? Well, there's three things. These we might call elements of the claim. We haven't yet had an example of elements, I don't think, or at least I haven't pointed it out if we did. And that these are the necessary ingredients to this type of legal claim. Comparison could be made to a recipe. Let's say I'm baking cookies. I'm baking sugar cookies. Well, the necessary ingredients would be flour, sugar, some kind of oil, or butter. Those would be the things you have to have. Now, I might like to add to my sugar cookies some vanilla, for example, or maybe some almond extract. Maybe I'd want to add some eggs to my mixture. Those would all be lovely additions, but they're not absolutely required. You could imagine a sugar cookie that didn't have vanilla or almond extract or eggs in it. And so when we talk about elements, we're talking about absolutely essential ingredients. And so you'll see here we're in a situation where we have the word and. We need all three of these ingredients. We might have more ingredients than these three ingredients. That's fine. You can have more, but if you're missing one of your necessary ingredients, you don't have a whistleblower claim. Just like if you leave out the sugar in your sugar cookie recipe, you don't have sugar cookies. You might have something tasty, but it's not a sugar cookie. So what do we need here? What are our elements or required components? Well, the first thing is that the employee had to have been participating in whistleblowing. It's pretty obvious. You can't be a whistleblower if you're not blowing that whistle. It can't typically be that he was thinking about it or she was considering it, or she would have had the opportunity in the future to do that. No, it's not a theoretical thing. And there could be times where the person is threatening to whistleblow and then gets fired before he or she is actually able to whistleblow. But at least it's in the process of being discussed. The next thing is that something bad at the employment situation has to have happened to the employee. The employer has to have done something. It doesn't have to be dismissal. It could be demotion or a suspension or a move to a less favored shift or something along those lines. But it has to happen. And then, of course, the third thing is that there has to be a connection between the whistleblowing and the adverse action. It certainly has to be a connection in terms of time. Obviously, the whistleblowing or the threat of whistleblowing has to happen first, and then the negative action has to happen. But just the ordering isn't enough. There has to be some evidence that the negative action happened because of the whistleblowing. And oftentimes, this is the most difficult part for the employee to prove. So when we're looking at what type of whistleblowing applies, an employee who complains about a boss who's mean isn't whistleblowing, because being mean isn't a crime, or being unfair isn't a crime. It needs to be a violation of some law, rule, or regulation, or it has to be some kind of gross mismanagement. I guess it should be mismanagement here. Let me add mismanagement here. Gross mismanagement or a gross abuse of funds that is causing a danger to the public health or safety or the public assets. So even if you're describing something unpleasant, unfortunate, stupid, mean, that isn't whistleblowing. It's only whistleblowing when you have one or both of these situations. We're going to talk about two federal statutes. As I said before, we're going to be focusing on federal related type activities. And the first is the False Claims Act. Now, the name of the statute, to me, I find very confusing. When I hear this, it sounds like the employee has made a false claim. That's not what it's about. It is about when the employee reports that his employer has made a false or inaccurate claim for funds from the government. So this would come up when the employer is a federal contractor. And so maybe the job of the business is to build a road, and they are supposed to bill the federal government for the cost of the asphalt. Well, the asphalt cost this particular employer, $100,000. And under the terms of the contract, they're able to add a 10% surcharge on that. So the amount of the bill should be $110,000. But they bill the federal government $150,000. So $40,000 was in excess. That would be a false claim. an employee at the federal contractor finds out about that and reports that to the federal government. That would be an example of action under the False Claims Act. So the government can bring the claim, or the individual can bring the claim himself. The individual kind of gets a finder's fee. I think it's 10%. So in that case, the individual could receive a recovery of up to maybe $4,000 for that particular claim. These are examples of the types of situations where false claims commonly arise. Again, this isn't going to work in most private employment because most private employment doesn't involve a connection to the federal government. The second one, though, is a more important area for most of our practices, and that has to do with the Sarbanes-Oxley Act. Sarbanes and Oxley were senators, and even though that's the name of the act, it is oftentimes called SOX. As you can see, the first letter of Sarbanes, and then we have Oxley is a SOX. So most commonly it's referred to as SOX. This gives additional protection to whistleblowers, but only if the employees are working for public companies. So when I say public companies, I mean companies who has shareholders that are not, it's not a privately held company. So these are shareholders whose shares, and the shareholders are in some sense strangers to the company. This might be is a publicly traded stock, on some kind of stock exchange type situation. And so under those circumstances, okay, so I'm going to end our call right now and our presentation right now, and then we'll pick up this presentation in another lecture. Thank you for your attendance, and thank you. Have a wonderful day. Take care.